The fundamental freedoms contained in the Charter of Rights are its foundation.
An example of why fundamental freedoms are important, I think, can be seen in the fact that there is the danger of the tyranny of the majority, of hysteria, of in a time of crisis, a problem comes up and there's a great temptation to take away the freedoms of people.
If we're to have a healthy democracy, we have to have citizens who are capable of exercising free and informed choice. And really what those fundamental rights and freedoms do, the right of thought, the right of association, the right of freedom of religion, freedom of expression, they say that every individual in our society has the right to participate on matters of public concern and to have his or her individual thoughts and beliefs respected in that process.
Alan Borovoy is General Counsel for the Canadian Civil Liberties Association. His organization monitors policy and supports human rights issues.
Well, if we're talking about freedoms such as freedom of speech, freedom of the press, freedom of association, freedom of assembly, one of my favorite philosophers once called these the strategic freedoms, the freedoms on the basis of which other freedoms get protected. We've learned from lots of experience that injustice is less likely to endure or even to emerge in an atmosphere of free public debate. Shine the spotlight of public opinion on an injustice, and you increase the prospects that that injustice can be overcome.
Judges have certain powers, parliamentarians have certain powers, civil servants have certain powers, but ultimately the power over all of those is the power of the press and open public scrutiny of public issues. I think it's a very important way of disciplining and controlling those who have power in our society.
Sheila Copps is the former Minister of Canadian Heritage. In that role, her responsibilities included both media and culture.
I think the freedom of the press as a guarantee within the Charter is excellent in theory. I think in practice, one of the questions that we have to ask ourselves now is, in the world of convergence, how much of the editorial decisions are made on the basis of other commercial interests? And I think that is a question that's troubling to Canadians and for which we need to find some long-term answers.
The concept of freedom of expression is reinforced through freedom of the press and through freedom of religion.
Well, I think that it's important under the whole heading of freedom of religion that the Charter included what one would expect it to include, the fact that the freedom of religion must be allowed and protected in every way by the Constitution. That doesn't mean, though, that religious values have to be promulgated, because the Constitution, I think, is very important to protect the whole country, and it means that we are looking at a secular human rights charter which protects people as in a secular way to equality. It doesn't make any difference what one's religious views are. The government has the responsibility to apply the law to everyone equally.
The Charter ensures basic democratic rights and a democratic government for Canadians. This is one of the areas of the document applying uniquely to Canadian citizens. The Charter guarantees regular elections will be held, that citizens may run for public office, and that citizens over the age of 18 may vote. For many new Canadians, these democratic freedoms signal their arrival.
I think that the important thing for us to keep in mind, both as citizens and as judges and participants in the process, is to make sure that the Charter is consistent with democracy, that the Charter is a way of enriching our democracy, protecting minority groups who can be overlooked by majorities, and ensuring that majorities exercise their power in a responsible fashion.
Avi Go is director of the Metro Toronto Chinese and Southeast Asian Legal Clinic. Her organization works to protect and promote the rights of new Canadians within the Asian community. Until they have citizenship, immigrants are not full participants in Canada's democratic rights.
Immigrants themselves don't have the right to vote. When they don't have the right to vote, they don't have a right, or the government would not necessarily perceiving them of having any right to challenge the law that affects them directly. Before the 1980s, certain new immigrants, permanent residents, did have the right to vote at the municipal and provincial level. But that right was taken away for good reasons, because those rights at the time were only granted to British subjects, right? So, I mean, to be fair, you know, that all immigrants should have the right to vote as opposed to just some immigrants.
Katie Coleman-Nickel married a Canadian and moved to Canada from the United States. She has witnessed the changing face of Canada through the children she teaches. After 25 years, she took her oath of citizenship and was sworn in as a Canadian.
I was really intrigued with how important it is in Canada for us not only to have the rights, but to have the responsibilities. I think that was stressed also by the judge who swore us all in, saying, you're now Canadians, but more importantly than having your rights, you have responsibilities with those. You have responsibility to make sure that other people aren't discriminated against the way you might have been in your native country. But now that you have the right to vote, it's important that you do your homework and you find out about the candidates.
I affirm that I will be faithful and bear true allegiance
Despite the strength of its democratic and equality rights and the values it represents, many believe the Charter has some inherent weaknesses.
The Charter uses very general terms like unreasonable arrest and detention, unreasonable search and seizure. And of course, that requires a great deal of subjectivity on the part of the judges.
There are really two main limitations on charter rights. One is the general limitation. Lawyers call it Section 1, which says that the rights are guaranteed, but they're subject to such reasonable limits as can be justified in a free and democratic society. So it's always open to Parliament or to a legislature to argue that we really need to limit this right or that right in order to protect some important interest. And it's up to the courts to assess that. The second limitation, of course, is the notwithstanding clause, the right of Parliament or a legislature to say that this law shall apply, notwithstanding the Charter. Rarely used, but it's there.
The notwithstanding clause was controversial. Mr. Trudeau didn't like it. But I realized that this was the only way we were going to arrive at a respectable, honorable compromise with those premiers who sincerely believed in the importance of parliamentary supremacy.
The notwithstanding clause, as you probably know, allows for the federal government or the provincial government to pass a law that is not in accordance with the Charter of Rights and Freedoms. And this means that province can pass laws that may be in fact very discriminatory. But they can only do it for 5 years. They can renew it again for another 5 years. Well, this is not very good. After all, what's the point of having a charter if it means that somebody can override it and override it and override it?
Now, I expected that this would create a major political hurdle for any government using the notwithstanding clause, and that's borne out to be an accurate forecast.
I would have thought that that was ultimately one of the values of having that notwithstanding clause there, so that it's the way of ultimately playing out that tension between parliamentary sovereignty and entrenched rights.